Chapter 11. Monaco, a principality upon bones, a gaming house with a flag. Monaco occupies a peculiar, almost caricatured station in the European monarchical pantheon. It is no kingdom. It is not even a grand duchy, like Luxembourg. It is a principality, the Principat de Monaco. The title of its ruler is prince, not king. The status of the state is so diminutive and so dependent that, throughout the greater part of its history, it has been no sovereign entity, but a protectorate, first of Spain, then of France, then of Sardinia, and then of France once more. And even today, when Monaco is a member of the United Nations and employs the euro, its sovereignty remains truncated. By the Treaty of 1918, should the House of Grimaldi become extinct, the principality passes automatically under the full sovereignty of France. Yet why has Monaco survived it all? Why have the great powers, who swallowed entire kingdoms and duchies with an unimpaired appetite, not swallowed up this microscopic scrap of rock? The answer is at once cynical and instructive. Monaco has survived, not because it was strong, not because it possessed an ancient and respected dynasty, not because its people fought fiercely for their independence. It survived because it learned to make itself useful as an anomaly. In the 19th century, having lost 95% of its territory and every source of revenue, the principality found itself confronted with a choice: to vanish from the map or to invent itself afresh. And it did invent itself. In 1856, Prince Florestan legalized games of chance, and his successor, Charles III, opened the casino at Monte Carlo in 1863. Why did the stratagem succeed? Because in both France and Italy, the gaming business was forbidden. Monaco became the sole lawful place where the European aristocracy and haute bourgeoisie could dissipate their fortunes at the roulette wheel. Thereafter, in 1869, Prince Charles III abolished personal income tax for residents, a gesture that, at the moment, seemed a mere administrative trifle, yet which fixed the destiny of the principality for all time. Monaco transformed itself into a tax haven long before the term had entered common parlance. Hither flocked the wealthy of the whole world, not because the living was good, though the climate and the views are superb, but because here one could pay no taxes. The sovereignty of Monaco is no fruit of a people's struggle for independence. It is a business model. The principality subsists because it furnishes services that are forbidden among its neighbors: games of chance in the 19th century, the evasion of taxes in the 20th and 21st. This is no state in the classical sense. It is a service station for billionaires, which the great powers have suffered to style itself a principality because it is convenient to do so. France tolerates Monaco, not out of reverence for an ancient dynasty, but because it is a useful thing to have a pocket principality tucked under one's elbow, whither delicate financial operations may be directed. From the standpoint of classical dynastic law, Monaco is not even a monarchy. It is a feudal holding which, by an accident of history, has escaped absorption by its larger neighbors, and has succeeded in converting its microscopic dimensions into a fountain of fabulous wealth. The House of Grimaldi, which has governed Monaco since 1297, is no royal house. It never has been. Its members were Genoese patricians, corsairs, condottieri, seigneurs, anything at all, save kings. The title of Prince of Monaco was formally assumed only in the 17th century, and even then, by the grace of the French king, and not by right of conquest or divine anointment. In this chapter, we shall apply the criteria of classical legitimacy to the Monegasque monarchy, and the verdict shall prove, perhaps, the most humiliating of all. For Monaco is not a state with a monarchy. It is a casino with a flag, a gaming house that the great powers have permitted to call itself a principality in exchange for the renunciation of all pretensions to anything serious. 11.1. A principality, not a kingdom, a title that cries vassalage aloud. The first thing that strikes the eye is the very title of the ruler. Prince of Monaco, not king, not emperor, a prince. In the feudal hierarchy, a prince is a title that may signify anything at all, from a king's son to the independent ruler of a microscopic state. Yet, in the case of Monaco, this title has an altogether concrete origin. It was bestowed by the French king. In 1641, Honoré II Grimaldi signed the Treaty of Peronne, which exchanged the Spanish protectorate for a French one. In gratitude for having come over to the side of France, Louis XIII bestowed upon him the title of Prince of Monaco, together with the Duchy of Valentinois. This was no act of recognition of sovereignty. It was an act of vassalic favor. The seigneur of Monaco became a prince, yet remained the vassal of the French crown. And even today, when Monaco is a member of the United Nations and of the Council of Europe, its ruler remains a prince and not a king. Why? The official version, such as the historical tradition. The real reason, an elevation of the title to a royal one would demand international recognition, an alteration of the constitution, and, most critically, would pose an awkward question: upon what ground, precisely, do the Grimaldis lay claim to royal status? They have never been kings. They were vassals of the French crown, thereafter of the Sardinian, and thereafter once more of the French. Their sovereignty is no fruit of conquest or of dynastic alliances. It is the fruit of diplomatic tightrope walking and of the knack of coming over to the winning side at the right moment. From the standpoint of classical dynastic law, this is a fundamental defect. A monarch must be a king. A prince is no sovereign. A prince is either a member of a royal family or the ruler of a vassal state. Monaco has never been fully sovereign in the medieval sense. It has always lain beneath someone's protection, and its rulers have never dared to style themselves kings because they knew their place. 11.2. The usurpation of 1297. Corsairs disguised as monks. Let us now turn to the foundation of the dynasty. It is a tale that is recounted with pride in Monaco, yet which, from the standpoint of legitimism, is the purest piece of criminality. On the 8th of January, 1297, Francesco Grimaldi, known as Malizia, the Cunning, an exile from Genoa and Guelph, disguised himself as a Franciscan friar and sought sanctuary within the fortress of Monaco, which was held by the Ghibellines. In the night, he threw open the gates to his men, who put the garrison to the sword and seized the fastness. This is no founding of a dynasty by right of conquest, the case in which one sovereign defeats another in a fair war. This is banditry. Francesco Grimaldi was no sovereign ruler. He was an exile, a corsair, an adventurer. He took the fortress by a trick, having disguised himself in the habit of a priest, an act which, in medieval Europe, was accounted not a ruse of war, but a sacrilege. What is more, the Grimaldis lost Monaco 3 times in the course of the succeeding 100 years, in 1317, in 1357, and in 1401. Only in 1419 did they at last establish themselves firmly upon the rock, purchasing the rights from Genoa. That is to say, their tenure was no continuous inheritance, but a sequence of captures, losses, and commercial transactions. From the standpoint of classical dynastic law, usurpation is not healed by the passage of time. If the founder of a dynasty seized the throne by deceit and murder, his descendants remain usurpers for all eternity. 700 years of rule do not wash away the original sin. The Grimaldis are no legitimate dynasty. They are a family of successful brigands, to whom fortune gave the chance to seize a rock that none of the great powers thought worth the wages of a serious war. 11.3. The Constitution of 1962. Bestowed, not popular. The Constitution of Monaco was granted by Prince Rainier III on the 17th of December, 1962. It was not adopted by a constituent assembly. It was not approved by a referendum. The prince simply gave his subjects a constitution, in the selfsame fashion that a medieval seigneur would grant a charter of liberties to his town. From the standpoint of modern constitutional law, this is an absurdity. A constitution must proceed from the people. It must be an act of the constituent power of the nation. In Monaco, the reverse is the case. The people subsist by the grace of the prince, and not the prince by the grace of the people. Article 2 of the Constitution declares, "The Principality of Monaco is a hereditary constitutional monarchy." Yet Article 3 adds the qualification, "The executive power belongs to the prince." Article 4, "The legislative power is exercised jointly by the prince and the National Council." Article 6, "The judicial power is exercised by the courts and tribunals in the name of the prince." This is no constitutional monarchy in the European sense. It is a dualistic monarchy, in which the prince retains a real authority. He appoints the ministers, including the Minister of State, who is traditionally a French functionary. He possesses the right of veto upon the laws. He may dissolve the parliament. He is the fountain of all authority. From the standpoint of classical dynastic law, this would appear, at first glance, to stand nearer to a legitimate monarchy than the British or Swedish models. The prince is a real sovereign, and not a marionette of parliament. Yet the difficulty lies in the fact that his sovereignty is incomplete. Monaco is no fully independent state. What is more, Until 2002, the following provision remained in force. Should the House of Grimaldi become extinct, Monaco passes automatically under the full sovereignty of France. This provision was repealed only in the new treaty. Yet, even today, France retains a right of veto upon any alteration of the order of succession and must be informed of any changes in the line of succession. The Prince of Monaco is no sovereign. He is a vassal of France, whose independence subsists for just so long as it is convenient to Paris. 11.4. The Law of 2002. The exclusion of adopted children from the succession, a terror of bastards. In April of 2002, 3 years before the death of Rainier III, the Constitution of Monaco was amended. The most important alteration touched the order of succession. Prior to 2002, the rule prevailed that, should the reigning prince have no lawful children, he might adopt an heir and transmit the throne to him. It was in this manner that Albert I had proceeded in 1919, when he adopted his illegitimate daughter, Charlotte, in order to prevent the throne from passing to the German Duke Wilhelm von Urach, a thing that was unacceptable to France on the eve of the First World War. The new redaction of the Constitution excluded the possibility of the succession of adopted children. Henceforward, the throne may pass only to the direct and lawful descendants of the reigning prince. If a prince has no lawful children, the throne passes to his brothers, his sisters, his nephews, and his nieces. Why was this done? The official version: to bring the Constitution into correspondence with modern standards. The real reason: a panic terror of the illegitimate children of Prince Albert. Albert II, the present Prince of Monaco, was, before his marriage to Charlene Wittstock in 2011, notorious as an inveterate bachelor and as the father of 2 officially acknowledged illegitimate children. Jasmine Grace Grimaldi, born 1992, the mother being the American Tamara Rotolo, and Alexander Coste, born 2003, the mother being the Togolese French flight attendant Nicole Coste. Beyond this, unconfirmed suits have been brought by other women who assert that Albert is the father of their children. Before 2002, Albert could, in theory, have adopted any of these bastards and made him his heir. The new constitution shut that door forever. Even if Albert were to adopt Alexander, the latter could not acquire the rights to the throne. The sole way for an illegitimate child to enter the line of succession is for his parents to enter into a lawful marriage and thereby to legitimate his birth. Yet Albert is married to Charlene, and he does not intend to divorce her, notwithstanding the manifest shipwreck of that marriage, of which the gutter press cries aloud. The law of 2002 is an act of the purest dynastic caprice. The reigning prince, fearing that his illegitimate offspring might lay claim to the throne, altered the constitution in order to exclude such a possibility. He did so, not out of reverence for dynastic law, which in any case excludes bastards, but out of dread of a scandal and of French pressure. France, which possesses a right of veto over any alteration of the order of succession, made its meaning plain beyond ambiguity. No bastards upon the throne of Monaco. This is no monarchy. It is a family business, in which the proprietor alters the statutes in order to bar undesirable kinsmen from the management. 11.5. The Crisis of 1918. How France imposed a dynasty upon Monaco. To grasp the full depth of the illegitimacy of the Monegasque monarchy, it is necessary to go back to the events of 1918 to 1919. This is a history that the Grimaldis prefer not to recount. In 1918, the reigning Prince Albert I found himself confronted with a dynastic crisis. His sole lawful son, Louis, was a bachelor and childless. The next in the line of succession was a German duke, Wilhelm von Urach, a descendant of the Grimaldis through the female line. The First World War was raging. France, bleeding to death in the trenches, could not suffer a German to sit upon the throne of Monaco, which lay but a few miles from Nice. France imposed upon Monaco the Treaty of Versailles of 1918, not to be confused with the Treaty of Versailles of 1919. This treaty, signed beneath the muzzles of the French guns, established that, should the House of Grimaldi become extinct, Monaco would pass automatically under the full sovereignty of France. In addition, France obtained a right of veto upon any alterations in the order of succession. The Minister of State of Monaco, the head of the government, must henceforward be a French functionary, appointed by the prince from a list furnished by the French government. To rescue the dynasty, Albert I took an unprecedented step. He adopted his illegitimate daughter, Charlotte, who had been born in 1898 of a liaison with a laundress, by other accounts, a cabaret singer. Charlotte became the lawful heiress. In 1920, she married a French aristocrat, Pierre de Polignac, who assumed the surname of Grimaldi. Their son, Rainier III, became prince in 1949. Mark well this juridical construction. The House of Grimaldi became extinct in the male line. The present Grimaldis are Polignacs, French aristocrats who assumed an alien surname in order to preserve the semblance of continuity. From the standpoint of classical dynastic law, this is a change of dynasty. Rainier III, Albert II, and their descendants are no Grimaldis by blood. They are Polignacs, usurping the name and the arms of an extinct line. Moreover, the very procedure of adoption was imposed by France. Albert I had no choice. Either he adopted Charlotte and preserved the appearance of independence, or Monaco became French territory. This is no free act of a sovereign's will. It is an act of capitulation before foreign pressure. From the standpoint of classical dynastic law, this is a fundamental illegitimacy. A monarch cannot be appointed by a foreign power. A monarch cannot be adopted in order to circumvent the dynastic statutes. A monarch must spring from the reigning house by blood. All that occurred in 1918 to 1919 was a juridical farce, staged by the French Ministry of Foreign Affairs in order to preserve a buffer state upon the Côte d'Azur. 11.6. Morganatic marriages and the dilution of the dynasty. The Monegasque dynasty, like all its European sisters, has systematically violated the principle of equal marriage. Yet, in the case of Monaco, this violation wears a peculiar hue, since the dynasty itself was reconstituted through an illegitimate daughter. Louis II and Ghislaine de Manget. Prince Louis II, the son of Albert I, married, in 1946, already then the reigning prince, Ghislaine de Manget, a French actress and a commoner. The union was childless and morganatic. Rainier III and Grace Kelly. Rainier III, in 1956, married Grace Kelly, an American actress. She was no aristocrat. Her father was a businessman, her mother, a housewife. The union was brazenly morganatic from the standpoint of classical law. Yet Rainier, himself the descendant of an adopted bastard, could lay no claim to purity of blood. Caroline and Stephanie, the daughters of Rainier III and Grace Kelly, contracted a series of scandalous marriages with commoners. Caroline married, first, Philippe Junot, a French playboy, divorced within 2 years. Next, Stefano Casiraghi, an Italian businessman, killed in 1990. And lastly, Ernst August of Hanover. At last, an equal marriage with a German prince. Yet even this union ended in separation and scandals. Stephanie married Daniel de Cruet, her own bodyguard, divorced. Thereafter, bore children by Jean Raymond Gottlieb, a chef, and thereafter by Adam Lopez Perez, a Portuguese acrobat. Albert II and Charlene Wittstock. The present prince, in 2011, married Charlene Wittstock, a South African competitive swimmer, the daughter of a sales manager and a schoolteacher. She possesses no royal blood. The union is morganatic. Their children, the twins Jacques and Gabriella, are the issue of a morganatic union. Summary table of the marriages of the Monegasque dynasty. Member of the dynasty's spouse extraction status of the union. Louis II Ghislaine de Manget, French actress, morganatic. Rainier III Grace Kelly, American actress, morganatic. Caroline, first marriage, Philippe Junot, French playboy, morganatic. Caroline, second marriage, Stefano Casiraghi, Italian businessman, morganatic. Caroline, third marriage, Ernst August of Hanover, German prince, equal. Stephanie Daniel de Cruet, bodyguard, morganatic. Albert II Charlene Wittstock, South African swimmer, morganatic. The result of the 7 marriages contracted within the Monegasque dynasty during the past 100 years, but a single one is equal. 6 are morganatic. The present prince, Albert II, and his heir, Jacques, are the descendants of a morganatic union. From the standpoint of classical dynastic law, they possess no right to the throne. 11.7. Juridical conclusion. A gaming house with a flag. Let us now draw the threads together. Let us apply to the Monegasque monarchy the criteria of classical legitimacy. Criterion status elucidation. Royal title absent Monaco is a principality and not a kingdom. The princely title was bestowed by the French king, not conquered. Blood extinct. The house of Grimaldi has expired in the male line. The present Grimaldis are Polignacs, adopted in 1919. Indigenat conditionally observed. The Grimaldis have ruled Monaco since 1297. yet their origin is Genoese and not native. Foundation of authority usurpation, the seizure of the fortress in 1297 by a trick, disguised monks. Thrice lost and thrice regained. Sovereignty truncated. Monaco is obliged to coordinate its succession with France. The Minister of State is a French functionary. Dynastic continuity grossly violated the crisis of 1918, the adoption of Charlotte, the change of the dynasty de facto. Absence of morganatic marriages systematically and grossly violated Rainier III, Albert II, Caroline, Stephanie, all unions with commoners. The monarch is not the servant of Parliament. Conditionally observed, the prince possesses real power, yet is limited by French oversight. Conclusion: the Monegasque monarchy is illegitimate upon every count. It is not even a monarchy in the classical sense. It is a feudal holding which, by an accident of history, has escaped absorption by France and has succeeded in converting its microscopic dimensions into a fountain of fabulous wealth by means of the gaming business. The Grimaldis are no royal dynasty. They are Genoese corsairs who seized a rock by a trick, lost it 3 times, bought it back, passed from one protector to the next, and, in the end, adopted a fresh bloodline for themselves under the pressure of France. The present prince, Albert II, is the descendant of a bastard, adopted to circumvent a dynastic crisis, married to a South African swimmer, the father of 2 illegitimate children whom the law of 2002 has forever barred from the succession. Monaco is no state with a monarchy. It is a casino with a flag, a gaming house that the great powers have permitted to style itself a principality in exchange for the renunciation of all pretensions to anything serious. Its sovereignty is a fiction. Its dynasty is a fiction. Its legitimacy is absolutely null. And when the Monegasques plume themselves upon their ancient principality, they plume themselves upon the most successful swindle in the history of Europe. 700 years ago, brigands seized a rock, and today their descendants levy tribute upon the tourists who flock thither to gape at the palace and to lose their money at the casino of Monte Carlo. In its essence, Monaco is a parasitical state, not in any vituperative sense, but in the strictly biological one, an organism that survives by feeding upon the resources of a larger host. The host is France. The resources are the capital that flees from French and other taxes. The service rendered is a lawful anomaly, a territory of exception where the laws of the neighbors do not apply. The paradox lies in this, that the parasitical nature of the thing is itself the sole foundation of Monaco's sovereignty. Strip away the casino, strip away the tax privileges, strip away the status of a haven for billionaires, and what remains? A rock with a palace that it would be impossible to maintain. A principality that France would annex within a week and would scarcely notice the exertion. The Grimaldis grasped this perfectly. Their entire policy, across the past century and a half, has been a policy of preserving their exceptionality. They do not build an army. They do not develop industry. They lay no claim to any geopolitical role. They simply see to it that the casino remains in operation, that the taxes remain at zero, and that the French protectorate remains sufficiently loose so as not to hinder the business. This is no monarchy. It is a family corporation owning an extraterritorial zone of pleasures and of financial services. And its sovereignty is nothing more than the license to carry on this trade, issued by the great powers and confirmed by the inertia of history.